The obsidian Tower of Justice pierced the crimson sky of Nexus Prime like a crystalline dagger, its black surfaces reflecting the dying light of 7 distant suns. For 12,000 years, this monument to galactic jurisprudence had stood as the ultimate arbiter of interstellar law, its halls echoing with the measured cadence of perfect legal procedure. Within its walls, the most complex disputes between star systems were resolved through an intricate dance of precedent, protocol, and procedural magnificence that had been refined across millennia. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. The tower's 97th floor housed the Supreme Tribunal Chamber, where Chief Arbitrator Velthak presided over the most significant cases in known space. His species, the Zephyrians, had evolved specifically for judicial work. Their neural architecture, naturally inclined toward logical analysis, their lifespans sufficient to accumulate centuries of legal wisdom, and their emotional dampening fields ensuring that passion never clouded judgment. Velthak's robes, woven from the silk of extinct ceremonial insects, rustled with the authority of 10,000 resolved cases. On this particular morning, as the 7 suns aligned in their ceremonial configuration that occurred once every 43 standard years, Velthak reviewed the docket with his customary precision. The Meridian Trade Dispute had been proceeding for 87 years, following established protocols that required each party to present their arguments in 17 distinct phases, with mandatory reflection periods between each presentation. The case involved territorial rights to a minor asteroid belt, but the legal precedents being established would influence interstellar commerce for generations to come. The courtroom itself was a marvel of architectural intimidation. Rising gallery seats accommodated representatives from 43 different species, each section climate-controlled to maintain the precise atmospheric conditions required by various forms of life. The central floor featured the Wheel of Justice, a rotating platform that ensured each speaker faced the cardinal directions according to ancient legal tradition. Above it all, holographic displays showed the relevant star charts, legal precedents, and the ever-present countdown timer that marked the procedural phases of each case. Velthak's primary concern this morning was not the Meridian dispute, however. After careful consideration by the Galactic Judicial Council, an unprecedented decision had been made to invite a representative from the recently discovered Terran system to observe tribunal proceedings. The humans, as they called themselves, had achieved faster-than-light travel only recently, and had established a rudimentary legal system that the Council found curious. Their inclusion was meant to demonstrate the galaxy's commitment to legal education and cultural exchange. What arrived was not what anyone had expected. Judge Sarah Martinez stepped off the transport shuttle, wearing what appeared to be a simple black robe, carrying a worn leather briefcase and, looking around the magnificent tribunal chamber, with the wide-eyed wonder of someone seeing a cathedral for the first time. She was small by galactic standards, her species lacking the imposing stature of the Zephyrians or the natural authority emanating pheromones of the Krulon delegates. Her hair was pulled back in a simple arrangement, and she wore no ceremonial jewelry or status indicators that would mark her position in any recognizable hierarchy. The first sign of trouble came during the mandatory orientation session. Protocol required that all observers undergo a comprehensive briefing on tribunal procedures, which typically lasted 14 hours and covered the essential elements of galactic jurisprudence. The session was conducted by Senior Clerk Thaddeus Morgrim, a Cantilian whose species had served as court administrators for over 3 millennia. Morgrim's multiple eyes could track dozens of legal documents simultaneously, and his voice carried the weight of absolute procedural authority. "The Galactic Tribunal operates on the foundation of eternal justice," Morgrim intoned, his voice resonating through the briefing chamber with practiced solemnity. "Our procedures have been refined over 12,000 years to ensure that every decision reflects the accumulated wisdom of civilized space. The first principle is procedural sanctity. Every case must follow the established patterns that have proven successful throughout history." Sarah raised her hand, a gesture that caused several automated systems to malfunction briefly as they attempted to interpret this unknown communication method. "I'm sorry, but when you say proven successful, what exactly do you mean by success? Are we talking about justice served, disputes actually resolved, or procedures correctly followed?" The question hung in the air like a malfunctioning gravity generator. Morgrim's eyes blinked in sequence, each one focusing on Sarah as if she were a particularly puzzling legal document. Success, he repeated slowly, is the proper execution of established procedure. Justice emerges from the faithful application of time-tested methods. But what if the procedures don't actually solve the problem? Sarah pressed. I've been reading about the Meridian Trade Dispute. It's been going on for 87 years over mining rights to an asteroid belt that was completely mined out 60 years ago. The original dispute is now irrelevant, but the case continues because procedure requires it. A ripple of discomfort passed through the assembled court staff. Morgrim's administrative tendrils twitched nervously as he consulted his procedural manuals. The Meridian case follows established precedent. Timeline is irrelevant to the legal principles being established. The asteroid belt's current state does not affect the territorial jurisdiction questions at the heart of the dispute. Sarah leaned forward, her expression genuinely curious rather than challenging. So we're spending decades of court time and millions of credits to establish legal precedent for a situation that no longer exists? How does that serve justice? Justice, Morgrim replied with the patience of someone explaining basic concepts to a child, is not about immediate resolution. It is about the proper application of law according to established principles. The immediate practicality of any single case is secondary to the maintenance of legal consistency across all cases. The human woman sat back in her chair, processing this information. I think I understand. The system prioritizes its own consistency over actually helping people solve their problems. The silence that followed was broken only by the soft hum of the chamber's atmospheric processors. Morgrim's eyes dilated as he struggled to formulate a response that would explain why such a characterization was both accurate and completely missing the point. The system, he finally managed, serves the greater good by ensuring that all disputes are handled with equal procedural rigor. Individual outcomes are less important than systematic integrity. Sarah nodded thoughtfully. And how often do the parties involved in these lengthy procedures actually get what they need to resolve their underlying conflicts? Morgrim consulted his statistical displays, though he clearly wished he didn't have to. Resolution satisfaction ratings are not typically tracked as they are considered secondary to procedural compliance ratings, which maintain an exemplary 99.7% success rate. So you don't actually know if you're helping people, Sarah said, not as an accusation but as a simple statement of fact. The orientation session continued for another 12 hours, but the tone had fundamentally shifted. Sarah asked questions that no one had thought to ask in millennia, questions that revealed assumptions so basic that they had become invisible. Why did evidence presentations require 7 distinct phases when 3 might accomplish the same goal? Why were parties required to argue positions they had already abandoned in the interest of reaching settlement? Why did the physical layout of the courtroom emphasize the authority of the court over the needs of the disputants? By the end of the session, Morgrim had filled out formal reports questioning whether the human observer was mentally competent to participate in tribunal proceedings. Her inability to grasp the fundamental importance of procedure over outcome suggested either severe cognitive limitations or a dangerous disregard for the foundations of civilized society. The next morning brought Sarah's first actual observation of tribunal proceedings. The Meridian case was entering its 47th procedural phase, which required the Altarian delegation to present their counter-arguments to the previous phase's rebuttals, following the traditional format of historical precedent, legal theory, and practical application. The Altarian representative, a crystalline being named Counselor Zenth, had been working on this presentation for 3 years. Sarah took her assigned seat in the observer's gallery, pulling out a simple notebook and pen, writing instruments that caused a minor stir among the court staff, who hadn't seen manual record-keeping in centuries. As Zenth began his presentation, following the prescribed ceremonial opening that honored the 7 suns, the 4 cardinal directions, and the eternal wisdom of the tribunal system, Sarah began taking notes. The presentation itself was a masterpiece of legal rhetoric. Zenth traced the historical development of territorial rights law across 17 different star systems, citing precedents that established the fundamental principles governing asteroid belt mining claims. His arguments were logically structured, thoroughly researched, and presented with the kind of scholarly precision that had made the Altarian legal system famous throughout the galaxy. After 4 hours of presentation, Zenth reached his conclusion. The Altarian position was that mining rights should be granted based on the original survey claims filed with the Galactic Mining Authority, regardless of subsequent political changes in the region. This position had been consistent throughout the 87 years of litigation. Chief Arbitrator Velthak responded with a traditional acknowledgement. The tribunal recognizes the scholarship and procedural excellence of the Altarian presentation. This matter will now proceed to the 48th phase, where the Meridian delegation will present their response to these arguments, following the established timeline of 3 months for preparation. As the court recessed, Sarah approached Zenth with her notebook in hand. "Counselor, I hope you don't mind me asking, but what outcome are you actually hoping to achieve from this case?" Zenth's crystalline structure shifted to display confusion. "Outcome? We seek legal recognition of our territorial claims according to established precedent." "But the asteroid belt has been completely mined out," Sarah pointed out. "Even if you win, there's nothing left to claim rights to. What would your people actually gain?" The question seemed to cause Zenth actual physical discomfort. His crystalline form flickered between different configurations as he processed this inquiry. The legal principle is what matters. The precedent established by this case will govern similar disputes for centuries to come. What if there's a way to establish the same precedent through a case that would actually benefit the people involved? Sarah asked, "I've been reading about territorial disputes in the Vega system that involve active mining operations. Wouldn't it be more efficient to establish precedent through a case where the outcome actually matters to the parties?" Zenth's form stopped flickering and settled into a pattern that his species associated with profound confusion. "But the Meridian case is already underway. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us." Now back to the story. The procedural investment has been made. To abandon it now would waste 87 years of legal work. Sarah made a note in her notebook, or it would free up resources to solve actual problems that still exist. Word of the human observer's unusual questions spread through the tribunal complex with surprising speed. By the afternoon session, several other observers and junior court staff had begun positioning themselves where they could overhear Sarah's conversations with the various parties involved in ongoing cases. The afternoon session involved the Kepler inheritance dispute, a case that had been in litigation for 34 years. The case concerned the distribution of a wealthy trader's estate among his 17 heirs from 4 different species, each with different cultural concepts of inheritance rights. The complexity arose from the need to reconcile 4 different legal traditions while maintaining consistency with galactic precedent. The current phase involved testimony from cultural experts who explained the inheritance customs of each species involved. The Vlaxian expert, Dr. Kenthor, was presenting a detailed analysis of how property rights transferred through matrilineal lines in traditional Vlaxian society, complete with historical examples dating back 2,000 years. Sarah listened intently, taking notes throughout the presentation. When Dr. Kenthor concluded, she approached him during the recess with her characteristic directness. "Dr. Kenthor, this is fascinating material, but I'm curious about something practical. The original estate was valued at 2 million credits 34 years ago. After 3 decades of legal fees and administrative costs, how much of the estate is actually left to distribute?" Dr. Kenthor's facial tentacles twitched with surprise. "The current value of the estate is not my area of expertise. I focus on the cultural and legal principles that should govern distribution." Sarah consulted her notebook, where she had been tracking financial information from the case files. According to the public records, the estate is now worth approximately 340,000 credits. The legal fees have consumed the majority of the value. Even if the case concludes tomorrow, each heir would receive less than they would have gotten from a simple equal distribution 34 years ago. This observation reached the ears of several heirs who were present in the gallery. The Kepler family members began gathering around Sarah, asking questions about the financial implications of continued litigation. Within minutes, she found herself in the center of an impromptu meeting where family members from different species were discussing the actual costs and benefits of the legal process for the first time in decades. The gathering was broken up by court security, who cited regulations about unauthorized assembly in judicial spaces. But the seed had been planted. The heirs began talking among themselves about the possibility of reaching a settlement outside the formal legal process. Chief Arbitrator Velthak observed these developments with growing concern. The human observer's presence was having an effect on the proceedings that went well beyond simple observation. Her questions were causing parties to focus on practical outcomes rather than legal principles, and this shift in perspective was beginning to affect the fundamental nature of the cases themselves. That evening, Velthak called an emergency meeting of the Senior Judicial Council. The meeting was held in the Chambers of Eternal Wisdom, a ceremonial space where the most important decisions about tribunal operations were made. The chamber was carved from a single piece of crystallized time, its walls displaying the accumulated precedents of 12,000 years of galactic jurisprudence. Fellow arbitrators, Velthak began, his voice carrying the weight of institutional authority. We face an unprecedented situation. The human observer's presence is disrupting the natural flow of legal proceedings. Her questions are causing parties to focus on immediate practical concerns rather than the broader legal principles that our cases are designed to establish. Senior Arbitrator Kalina, representing the Morphic Collective, rippled her agreement. The human displays a fundamental misunderstanding of the purpose of law. She treats legal proceedings as if they were problem-solving exercises rather than exercises in applying established principle to specific circumstances. Perhaps, suggested Junior Arbitrator Velthak, we should consider the possibility that the human perspective might offer some insights into improving our procedures. The silence that followed was profound enough to register on the chamber's atmospheric sensors. Kalina's form shifted to display what could only be described as scandalized shock. Are you suggesting that our procedures, refined over 12 millennia, might be improved by the crude problem-solving methods of a species that has had interstellar law for less than 50 years? Vaxon's bioluminescent patches flickered nervously. Not improved exactly, but perhaps supplemented. The human has identified some practical inefficiencies in our current system. Inefficiencies? Velthak's voice carried a tone that made several junior staff members in the chamber step back involuntarily. The efficiency of our system is measured by its consistency and procedural integrity, not by the speed of resolution or the satisfaction of the parties involved. Those are secondary considerations. But what if they don't have to be secondary? Velthak persisted. What if we could maintain our procedural integrity while also ensuring that our decisions actually help the people who come before us? The question hung in the chamber like a violation of natural law. The accumulated precedents displayed on the walls seemed to flicker in response to this fundamental challenge to their relevance. Kalina's form solidified into a configuration that her species used to express absolute certainty. The moment we begin prioritizing immediate practical outcomes over legal consistency, we begin the destruction of the rule of law itself. Justice is not about making people happy. It is about applying consistent principles uniformly across all cases. And yet, Velthak replied, his bioluminescence now steady with conviction, I reviewed the case files that the human has been examining. The Meridian dispute is costing both parties more in legal fees than the original asteroid belt was worth. The Kepler inheritance has been consumed by the process of distributing it. The Antares trade agreement has been in litigation so long that the trade routes it was meant to regulate have been abandoned. Are these really examples of justice being served? The chamber's temperature regulation systems activated as the assembled arbitrators processed this unprecedented challenge to their fundamental assumptions. For 12,000 years, the tribunal had operated on the principle that proper procedure inevitably led to just outcomes. The suggestion that procedures might need to be evaluated based on their actual results was revolutionary in the most dangerous sense. Velthak stood, his robes rustling with the authority of his position. These concerns will be noted in the official record. However, I believe we must focus on the immediate problem: the human observer's disruptive influence on ongoing proceedings. I propose that we implement enhanced observation protocols that limit her ability to interact with case participants. The vote was unanimous, though Velthak's agreement came with visible reluctance. Enhanced observation protocols were implemented immediately, restricting Sarah to a sealed observation booth where she could watch proceedings but not interact with participants. The next morning, Sarah arrived at the tribunal to find herself escorted to her new observation post. The sealed booth was equipped with advanced translation systems and comfortable seating, but it was clearly designed to keep her separate from the actual proceedings. The message was clear: observe, but do not interfere. Sarah examined the booth with the same curious attention she had given everything else in the tribunal complex. She tested the communication systems, reviewed the technical specifications, and then did something that no one had anticipated. She began broadcasting her observations to the public networks. "This is Judge Sarah Martinez, observing proceedings at the Galactic Tribunal," she began, speaking into her personal communication device. "I'm currently watching the continuation of the Meridian Trade Dispute, which has been in litigation for 87 years over mining rights to an asteroid belt that was completely mined out 60 years ago. The broadcast was initially noticed by only a few thousand viewers across the galaxy, mostly legal scholars and government officials with professional interest in tribunal proceedings. But Sarah's approach to describing the cases was unlike anything they had ever heard. "The legal arguments are absolutely fascinating," she continued, "and the scholarship is impressive. But I keep coming back to a basic question. What problem are we actually trying to solve here? The original miners have found other work. The companies involved have moved on to other projects. The only people who still care about this dispute are the lawyers and the judges." She paused, watching as the Meridian delegation presented their 48th phase arguments with the same scholarly precision that had characterized the previous 47 phases. "And I keep wondering, what would your mother think if she saw you spending 87 years arguing about something that stopped mattering 60 years ago?" The question was asked casually, almost as an aside, but it began to spread through the galactic communication networks with viral intensity. Within hours, "What would your mother think" had become a shorthand for asking whether legal procedures were actually serving their intended purpose. The phrase reached the participants in the Meridian case by afternoon. For the first time in 87 years, the lawyers and delegates found themselves facing not just legal challenges, but public scrutiny that focused on the practical value of their work. News services began running stories about the case, not from the perspective of legal precedent, but from the perspective of resource allocation and practical outcomes. The Altarian delegation, led by Councillor Zenth, found themselves answering questions from their own government about why they had spent the equivalent of a small planet's GDP on a legal case that could no longer achieve its original objectives. The Meridian representatives faced similar inquiries from their constituents, who were beginning to understand that their tax credits had been funding a legal argument that had outlived its relevance. By the end of the week, both delegations had quietly approached the tribunal administration about the possibility of reaching a settlement that would allow them to withdraw from the case while establishing some form of precedent for future disputes. The request was so unprecedented that the tribunal's administrative systems initially rejected it as a clerical error. Chief Arbitrator Velthak found himself in the impossible position of having to explain to the Senior Judicial Council why parties were suddenly interested in resolving their disputes outside the formal legal process. The human observer, isolated in her sealed booth, had somehow catalyzed a shift in perspective that was affecting not just the immediate cases, but the entire relationship between the tribunal and the galactic community it served. "The human's broadcast is being viewed by millions of beings across the galaxy," reported Communications Director Flaxus, her tentacles writhing with anxiety. "She's presenting our cases as examples of bureaucratic inefficiency rather than legal scholarship. Public opinion is beginning to shift against the tribunal's traditional methods." "Public opinion," Velthak replied with as much dignity as he could muster, "is not relevant to the proper administration of justice. The tribunal serves the law, not popular sentiment." "But what if the law serves no one?" asked Junior Arbitrator Vaxon, whose questioning had become increasingly bold since the human's arrival. "What if our commitment to procedural perfection has made us irrelevant to the actual needs of the people we're supposed to serve?" The question echoed through the chamber like a challenge to the fundamental order of the universe. For 12,000 years, the tribunal had operated on the assumption that proper procedure inevitably served justice. The suggestion that justice might require something more than proper procedure was more than revolutionary. It was heretical. And yet, as the week progressed, the evidence became impossible to ignore. The Kepler inheritance heirs had begun meeting privately to discuss settlement options. The Antares trade agreement parties had withdrawn their case entirely, choosing to negotiate directly rather than continue litigation over trade routes that no longer existed. 3 other long-standing cases had been resolved through direct negotiation between the parties, who had decided that practical solutions were more valuable than legal precedents. The tribunal, for the first time in its history, was losing cases not through adverse judgments but through the parties' realization that the legal process was not serving their actual needs. The system that had been designed to be the ultimate arbiter of interstellar disputes was being bypassed by the very people it was meant to serve. Sarah, meanwhile, continued her broadcasts from the observation booth, describing each day's proceedings with the same combination of respect for the legal scholarship and bewilderment at the practical irrelevance of the cases. Her question, "What would your mother think?" had become a rallying cry for anyone who had ever been frustrated by bureaucratic procedures that seemed to serve their own perpetuation rather than any useful purpose. The phrase began appearing in contexts far beyond the tribunal. Government officials found themselves facing the question when they proposed regulations that would create more administrative work without solving actual problems. Corporate executives heard it when they implemented procedures that made their companies less responsive to customer needs. Even other courts throughout the galaxy began using the phrase as a test for whether their procedures were actually serving justice. Chief Arbitrator Velthak realized that the tribunal was facing an existential crisis. The human observer had not attacked their system directly, had not challenged their authority, had not even criticized their procedures. She had simply asked whether those procedures were actually accomplishing their stated purpose. And in doing so, she had exposed a fundamental disconnect between the tribunal's means and its ends. The crisis came to a head during the third week of Sarah's observation period. The Vortian sovereignty had brought a case against the Helix Confederation regarding territorial boundaries that had been in dispute for over 2 centuries. The case was being presented as a matter of crucial importance to galactic stability, with both sides arguing that the precedent established would affect boundary disputes throughout known space. Sarah's broadcast that morning began with her usual respectful description of the legal arguments and scholarly presentations. But then she asked the question that would change everything. "I've been looking at the historical records, and I'm curious about something. The original boundary dispute between the Vortian sovereignty and the Helix Confederation was caused by a cartographical error in the original survey. Both sides have known this for over a century. The actual boundary they're arguing about runs through empty space. There are no planets, no resources, no strategic value. So why are they spending billions of credits and decades of time arguing about it?" The question was broadcast live to an audience that now numbered in the hundreds of millions. Within hours, investigative reporters had confirmed Sarah's research. The Vortian Helix boundary dispute, which had been presented as a matter of crucial galactic importance, was indeed about a completely empty region of space that neither side actually wanted or needed. The revelation triggered a cascade of similar investigations into other high-profile cases. The Galactic resource allocation dispute was about mining rights to an asteroid field that had been destroyed in a stellar collision 50 years earlier. The Centauri navigation rights case concerned shipping lanes that had been abandoned after the development of new, faster-than-light technology. The temporal jurisdiction dispute involved legal principles that had been rendered obsolete by advances in time travel regulation. Case after case was revealed to be continuing, not because of practical necessity, but because of procedural momentum. The tribunal system had become so focused on maintaining consistency and precedent that it had lost track of whether its work was actually useful to anyone outside the legal profession. The public response was swift and unprecedented. Governments across the galaxy began questioning why they were funding a legal system that seemed designed to perpetuate itself, rather than solve actual problems. Citizens who had respected the tribunal as the ultimate arbiter of justice began to see it as an elaborate exercise in bureaucratic self-justification. The tipping point came when the Meridian and Altarian delegations, after 87 years of litigation, jointly announced that they were withdrawing from their case to pursue direct negotiation. In their public statement, they specifically cited the human observer's question. "We asked ourselves what our mothers would think if we continued to spend resources on a dispute that no longer served any practical purpose." Chief Arbitrator Velthak found himself facing a choice that no tribunal leader had ever had to make: adapt to a changing understanding of justice or maintain traditional procedures in the face of public rejection. The decision would determine not just the future of the tribunal, but the entire relationship between legal institutions and the societies they served. The next morning, Sarah arrived at the tribunal to find that her observation booth had been removed. In its place was a simple chair at a desk on the main floor of the courtroom, with a nameplate that read, quote, "Advisor for Practical Applications." Chief Arbitrator Velthak stood at the center of the chamber, his ceremonial robes somehow less imposing than they had been just weeks before. "The tribunal," he announced in a voice that carried both authority and uncertainty, "has decided to implement an experimental program. We will begin evaluating our procedures not just for their consistency with legal precedent, but for their effectiveness in achieving practical justice for the parties involved." The chamber erupted in chaos as legal scholars, court staff, and observers tried to process this revolutionary announcement. Sarah sat quietly at her new desk, making notes in her simple notebook, apparently unaware that she had just witnessed the collapse of 12,000 years of legal tradition. But the real transformation was just beginning. The question that had started as a simple inquiry about practical relevance had become a fundamental challenge to the relationship between procedure and purpose, between institutional authority and actual service. The tribunal that had once been the galaxy's most prestigious legal institution was about to discover what justice looked like when it was measured not by its adherence to tradition, but by its ability to help people solve their actual problems. The first test would come the following week, when the tribunal would have to decide not just what the law required, but what justice demanded. And for the first time in 12,000 years, those two things might not be the same. The experimental program began with the Aurora mining conflict, a relatively straightforward case involving disputed excavation rights on 3 uninhabited moons. Under the traditional system, this case would have required approximately 7 years of litigation to establish proper precedent regarding subsurface mineral rights in multi-moon systems. The parties involved were the Cerberus Corporation and the Independent Miners Guild, both of whom had been preparing for an extensive legal battle. Sarah's new position as advisor for practical applications meant she could now interact directly with the proceedings. Her first action was to request a meeting with both parties before any formal litigation began. This suggestion caused immediate consternation among the court staff, as pre-litigation consultation between opposing parties was not merely unusual, it was virtually unthinkable. "The purpose of the legal process," explained Senior Clerk Morgram, his multiple eyes blinking in rapid sequence as he processed this breach of protocol, "is to ensure that all arguments are presented formally within the structured environment of the courtroom. Private consultation between parties could lead to inappropriate settlements that fail to establish necessary legal precedent." Sarah nodded thoughtfully as she reviewed the case files. But what if the parties can resolve their actual dispute without needing to establish legal precedent? Wouldn't that save everyone time and resources while still achieving justice? The question caused Morgram's administrative tendrils to curl in distress. Justice emerges from the proper application of legal procedure, not from informal agreements between parties. Without formal proceedings, there is no guarantee that the resolution will be consistent with established law. What if we could achieve both? Sarah suggested. What if we could help the parties resolve their immediate problem while also documenting the process in a way that could inform future similar cases? This radical concept, that justice might emerge from problem-solving rather than precedent following, required an emergency consultation with the Senior Judicial Council. The meeting was held in the Chamber of Precedent, where the walls displayed every significant legal decision made in the tribunal's history. The accumulated weight of 12,000 years of jurisprudence seemed to press down on the assembled arbitrators as they grappled with this fundamental challenge to their understanding of legal process. Chief Arbitrator Velthak presented the issue with characteristic precision. The human advisor has proposed a methodology that prioritizes dispute resolution over precedent establishment. This approach would fundamentally alter the nature of our proceedings from legal analysis to what she terms, quote, practical problem solving. Senior Arbitrator Kalina's form rippled with disapproval. The suggestion reveals a fundamental misunderstanding of the purpose of law. Legal proceedings are not mere problem-solving exercises. They are applications of universal principles to specific circumstances, designed to ensure that justice is both served and seen to be served through consistent application of established rules. Junior Arbitrator Vaxon, who had become increasingly vocal in his support for procedural reform, glowed with cautious optimism. Perhaps we might consider this as an experiment in efficiency rather than a replacement for traditional methods. If the parties can resolve their dispute quickly while still generating useful legal guidance, we would achieve our objectives with greater resource efficiency. The debate that followed would have continued for the traditional 6 hours, if not for an unprecedented interruption. Dr. Elara Voss, representing Cerberus Corporation, and Captain Rex Hawthorne, speaking for the Independent Miners Guild, requested permission to address the council directly. This breach of protocol, parties in a dispute addressing the Judicial Council before formal proceedings had begun, was so unprecedented that the tribunal's procedural databases initially crashed trying to process the request. Honorable arbitrators, Dr. Voss began, her voice carrying the careful diplomacy of someone navigating uncharted legal territory. We have been informed of the tribunal's experimental approach to dispute resolution. After consulting with our respective organizations, we would like to request permission to attempt direct negotiation under the guidance of Advisor Martinez. Captain Hawthorne stepped forward, his weather-beaten features reflecting years of asteroid mining in hostile environments. Our dispute is fundamentally about resource allocation and operational safety. We believe that technical experts working together might resolve these issues more effectively than legal experts working in opposition. The request hung in the chamber like a violation of natural law. For 12 millennia, the tribunal had operated on the principle that legal disputes required legal solutions. The suggestion that the parties themselves might be better positioned to resolve their conflicts was more than revolutionary. It was heretical. Kalina's form solidified into a configuration of absolute rejection. The parties lack the legal expertise necessary to ensure that their resolution will be consistent with galactic jurisprudence. Their technical knowledge, while relevant to the facts of the case, cannot substitute for proper legal analysis. But what if their technical knowledge is more relevant to achieving justice than our legal analysis? Asked Vaxon, his bioluminescent patches flickering with conviction. What if the most just outcome is the one that actually solves their problem, regardless of its consistency with previous cases involving completely different circumstances? The question provoked a silence so profound that the chamber's atmospheric processors registered it as a potential system malfunction. The accumulated precedents displayed on the walls seemed to flicker in response to this fundamental challenge to their authority. Chief Arbitrator Velthak found himself facing a decision that would define not just this case, but the future direction of galactic jurisprudence. The Council will permit the experimental proceeding, he announced, his voice carrying both authority and uncertainty. However, all interactions will be documented and analyzed to ensure that any resolution achieved is consistent with the principles of galactic law. The experimental session was scheduled for the following morning in a chamber that had been hastily reconfigured to accommodate direct negotiation rather than formal argument. Instead of the traditional layout that emphasized the authority of the court, the room featured a circular table where all participants could interact as equals. The change in physical arrangement was symbolic of a much deeper shift in the relationship between legal institutions and the people they served. Sarah began the session not with formal presentations, but with questions designed to understand the actual nature of the dispute. Dr. Voss, Captain Hawthorne, can you help me understand what each of your organizations is actually trying to achieve on these moons? Dr. Voss consulted her technical displays before responding. Cerberus Corporation has identified significant deposits of rare earth elements on all 3 moons. Our extraction process requires large-scale surface operations that would maximize resource recovery while minimizing operational costs. Captain Hawthorne nodded respectfully before presenting his perspective. The Independent Miners Guild represents smaller operations that focus on precision extraction of high-value materials. Our members have been working these moons for 15 years, using sustainable techniques that preserve the geological integrity of the sites. So your conflict isn't really about who has the right to mine, Sarah observed, but about how the mining should be done? The simplicity of this reframing caught both parties off guard. Dr. Voss and Captain Hawthorne exchanged glances, recognizing that their fundamental disagreement had been accurately identified in a way that years of legal preparation had somehow missed. The legal issue is territorial jurisdiction, Dr. Voss clarified, though her voice carried less certainty than before. Our respective claims to mining rights are based on different interpretations of colonial settlement law versus mineral extraction precedent. But underneath the legal technicalities, Captain Hawthorne added slowly, the real issue is that our methods are incompatible. Large-scale extraction would destroy the precise operation sites that my members have spent years developing. Sarah made notes in her simple notebook as she processed this information. What would happen if, instead of fighting over exclusive rights, you worked together to develop extraction methods that served both objectives? The suggestion was so practical that it took several moments for both parties to process its implications. Traditional legal thinking focused on determining which party's claims were superior under existing law. The possibility of collaborative problem-solving that served both parties' interests was not merely unconventional. It was outside the conceptual framework of adversarial jurisprudence. Collaborative extraction would require significant technical coordination, Dr. Voss said thoughtfully. We would need to modify our operational procedures to accommodate existing precision sites, and we would need to accept some disruption to our established operations, Captain Hawthorne acknowledged. But if Cerberus provided technical support and market access, our members could potentially increase their yields significantly. Over the following hours, something unprecedented occurred in the chambers of the Galactic Tribunal. Instead of legal arguments about competing rights, technical experts began discussing practical solutions to shared challenges. Instead of adversarial presentations designed to prove one side right and the other wrong, collaborative analysis identified opportunities for mutual benefit. The breakthrough came when Dr. Voss realized that Cerberus Corporation's large-scale equipment could actually enhance the precision mining operations by providing better geological data and transportation infrastructure. Captain Hawthorne recognized that the Independent Miners Guild's knowledge of local conditions could help Cerberus avoid costly operational mistakes that had plagued similar projects on other worlds. We could establish a joint venture, Dr. Voss proposed, her scientific training adapting quickly to this new model of problem-solving. Cerberus provides infrastructure and technical support. The Guild provides operational expertise and site management. Profits are shared based on contribution rather than territorial claims. And environmental protection is built into the operational protocols from the beginning, Captain Hawthorne added, rather than being imposed as external regulation after the fact. The agreement they reached in 8 hours was more comprehensive and practical than anything that might have emerged from 7 years of traditional litigation. It addressed not just the immediate territorial dispute, but also environmental protection, worker safety, technology sharing, and long-term resource management. Most importantly, it was designed to be a model that other similar disputes could adapt, rather than a precedent that would constrain future cases. Chief Arbitrator Velthak observed these proceedings with a mixture of fascination and alarm. The human advisor had facilitated a resolution that was undeniably just and practical, but it had been achieved through methods that bore no resemblance to traditional legal process. The parties had ignored established precedent, bypassed formal argument procedures, and created an outcome that served their actual needs rather than legal consistency. The experimental proceeding has achieved a resolution, he reported to the senior judicial counsel that evening. But the methodology raises fundamental questions about the nature of legal process itself. What sort of questions? Asked Kalina, though her tone suggested she already suspected the answer would be disturbing. The parties resolved their dispute by focusing on their actual objectives rather than their legal positions, Velthak explained. They ignored precedent, created new collaborative frameworks, and achieved an outcome that neither traditional litigation nor existing law could have provided. Kalina's form rippled with distress. Such methodology undermines the entire foundation of legal predictability. If parties can simply negotiate outcomes based on their immediate needs, the law becomes irrelevant. Or, suggested Vaxon, the law becomes a tool for facilitating justice rather than an end in itself. The philosophical implications of this shift were staggering. For 12,000 years, the legal system had operated on the principle that justice emerged from the consistent application of established rules. The suggestion that justice might require flexibility, creativity, and attention to specific circumstances challenged the fundamental assumptions underlying galactic jurisprudence. The next test came sooner than expected. News of the Aurora mining resolution had spread throughout the galaxy with unprecedented speed, reaching the attention of parties involved in dozens of other long-standing disputes. Within days, the tribunal received formal requests from 17 different cases asking for experimental resolution sessions using the new methodology. The quantum frequency dispute involved communication rights to subspace channels that had been in litigation for 43 years. The parties, the Stellar Communications Consortium and the Emergency Response Network, had been arguing over technical specifications that had been rendered obsolete by advances in quantum technology. Under Sarah's guidance, they spent 2 days developing new collaborative protocols that actually improved emergency response times while expanding commercial communication capacity. The biological preserve controversy had pitted environmental protection advocates against agricultural development interests for over 60 years. Traditional legal analysis had focused on determining whether preservation or development had legal priority. Sarah helped both sides recognize that their apparent conflict was based on outdated assumptions about the incompatibility of conservation and agriculture. The resolution they reached integrated advanced ecological management with sustainable food production in ways that served both objectives more effectively than either could have achieved alone. Case after case demonstrated the same pattern. Disputes that had seemed intractable under traditional adversarial legal analysis proved to be collaborative opportunities when the parties focused on their actual objectives rather than their legal positions. The tribunal's caseload, which had been growing steadily for centuries, began to shrink dramatically as parties chose practical problem-solving over formal litigation. But success brought new challenges. The legal profession throughout the galaxy began to recognize that the experimental methodology threatened not just individual cases, but the entire structure of adversarial jurisprudence. If parties could resolve their disputes through direct collaboration, what role remained for lawyers, judges, and the vast institutional apparatus of formal legal process? The opposition crystallized around Senior Arbitrator Kalina, who began organizing what she called the Alliance for Legal Integrity. This coalition of traditional legal practitioners argued that the experimental methodology represented a dangerous abandonment of the rule of law in favor of ad hoc problem-solving that could not provide the predictability and consistency that civilized society required. The Human Advisor's methodology, Kalina declared in a public statement that was broadcast throughout the galaxy, reduces complex legal questions to simple engineering problems. While such approaches may achieve immediate practical results, they undermine the systematic application of legal principle that protects all citizens from arbitrary decision-making. The statement provoked a passionate response from Dr. Voss and Captain Hawthorne, whose joint venture had become a model for collaborative resource development throughout their sector. The traditional legal system, they replied, spent years arguing about our rights while ignoring our actual needs. The experimental methodology helped us achieve a resolution that serves justice better than any decision imposed by formal legal process could have done. Their exchange triggered a galaxy-wide debate about the fundamental purpose of legal institutions. Traditional legal scholars argued that law must be consistent and predictable to be just, even if individual outcomes seemed inefficient or impractical. Reform advocates countered that legal systems that failed to serve the actual needs of real people were just elaborate exercises in institutional self-perpetuation. The debate reached a crescendo when the Interstellar Bar Association filed a formal complaint against the Galactic Tribunal, alleging that the experimental methodology violated the fundamental principles of due process and legal representation. The complaint argued that parties who resolved their disputes through direct collaboration were being denied their right to proper legal advocacy and formal judicial review. Sarah's response to this complaint would become one of the most significant statements in the history of galactic jurisprudence. Instead of defending the experimental methodology through legal argument, she posed a simple question that cut to the heart of the controversy. Who does the legal system serve? She asked during a public forum that was broadcast to billions of beings throughout the galaxy. Does it serve the lawyers and judges who operate it? Or does it serve the people who need their disputes resolved? If the answer is that it serves the people, then we should measure its success by how effectively it helps them solve their problems. If the answer is that it serves the legal profession, then we should measure its success by how well it maintains traditional procedures, regardless of whether those procedures actually help anyone. The question reframed the entire debate. Instead of arguing about methodology or procedure, Sarah had focused attention on the fundamental purpose that legal institutions were supposed to serve. The response from the galactic community was swift and decisive. Citizens who had been frustrated by lengthy legal procedures that seemed designed to benefit lawyers more than disputants began demanding access to experimental resolution methods. Governments that had been funding expensive legal systems with questionable practical results started questioning whether their investment was actually serving justice. Even some members of the legal profession began acknowledging that their traditional methods might need fundamental reform. The pressure for change became irresistible when the Emperor of the Centauri Alliance publicly announced that his government would no longer participate in traditional tribunal proceedings for commercial disputes. "We will seek practical resolutions that serve our people's needs," he declared, rather than legal precedents that serve the legal profession's interests. Within weeks, 17 other major governments had made similar announcements. The Galactic Tribunal found itself facing a choice that no legal institution had ever confronted: adapt to serve the actual needs of the people who sought justice, or maintain traditional procedures in the face of public rejection. Chief Arbitrator Velthak realized that the tribunal was not just facing a crisis of methodology, but a crisis of legitimacy. The institution that had once been regarded as the ultimate arbiter of interstellar justice was being bypassed by the very people it was meant to serve. The choice was no longer between traditional and experimental methods, but between relevance and obsolescence. The transformation that would follow would challenge every assumption about the relationship between legal institutions and the societies they served. The human advisor's simple question about practical purpose had exposed the difference between serving the law and serving justice, and that difference would reshape the very foundations of galactic civilization. The final confrontation came on the anniversary of Sarah's first day at the tribunal. The Alliance for Legal Integrity had organized a formal challenge to the experimental methodology, demanding a return to traditional procedures through the ancient rite of institutional review. This archaic process required the senior judicial council to defend their operational decisions before a tribunal of their peers from across the galaxy. Chief Arbitrator Velthak stood before an assembly of 200 legal scholars, representing every major judicial system in known space. The chamber had been configured in its most traditional format, with ceremonial robes, formal protocols, and the accumulated weight of institutional authority pressing down on every participant. The question before this assembly, announced Grand Jurist Morvac of the Universal Legal Consortium, is whether the Galactic Tribunal has abandoned its fundamental duty to uphold consistent legal principle in favor of expedient problem-solving that undermines the rule of law itself. Velthak felt the crushing weight of 12,000 years of precedent as he prepared to defend decisions that had seemed logical weeks ago but now appeared revolutionary in their implications. The traditional response would be to cite procedural authority, reference established precedent, and demonstrate compliance with institutional regulations. Instead, he found himself asking the question that had started it all. "What would your mother think?" Velthak said quietly, "if she knew we spent centuries arguing about procedures while people's actual problems went unsolved?" The silence that followed was absolute. Grand Jurist Morvac's ceremonial appendages twitched as he processed this unprecedented breach of formal discourse. "Arbitrator Velthak, you are expected to present legal justification for your tribunal's actions, not philosophical speculation." "I am presenting the only justification that matters," Velthak replied, his voice gaining strength. "We have helped more beings achieve actual justice in 6 months than we managed in the previous 6 centuries. The Aurora mining partners now work together instead of fighting. The quantum frequency dispute parties created solutions that improved emergency response for billions of people. We stopped arguing about law and started delivering justice." Senior Arbitrator Kalina rose from the assembly, her form radiating institutional outrage. "You speak of individual successes while ignoring systematic failure. Without consistent legal precedent, there can be no equal treatment under law. Your experimental methodology creates arbitrary outcomes based on the particular circumstances of each case." "Exactly," said Sarah Martinez, stepping forward from the observers section where she had been sitting quietly. "We create outcomes based on the particular circumstances of each case, because every dispute involves real people with specific needs, not abstract legal principles with universal applications." Her presence in the formal review chamber was itself a violation of protocol, but Grand Jurist Morvac seemed too stunned by the ongoing breakdown of procedural order to object. The human advisor will explain how individual problem-solving can substitute for systematic legal analysis. Sarah approached the central platform with the same straightforward manner that had characterized all her interactions with the tribunal. "Your Honor, I've been watching galactic legal systems for 8 months now, and I've noticed something interesting. The more complex your procedures become, the less they actually help the people who need justice." She gestured to the assembled legal scholars, their ceremonial robes and formal positions representing centuries of accumulated institutional authority. Every person in this chamber became a legal professional because they wanted to serve justice. But somewhere along the way, serving the law became more important than serving justice. The procedures became more important than the outcomes. "Legal procedures ensure fairness," interrupted Kalina. "Without systematic application of established principles, justice becomes arbitrary preference." But what if systematic application of established principles makes justice impossible? Sarah asked. What if your procedures are so focused on consistency that they consistently fail to help people? She pulled out her simple notebook, the same one she had been using since her first day at the tribunal. I've been tracking the results of traditional legal proceedings versus collaborative problem-solving. Traditional methods resolve about 30% of cases within 5 years, with average satisfaction ratings of 42%. Collaborative methods resolve 97% of cases within 2 weeks, with satisfaction ratings of 91%. The statistics hung in the chamber like an indictment of everything the assembled legal professionals had dedicated their lives to achieving. Grand Jurist Morvak's voice carried a note of desperation as he responded. Satisfaction ratings are irrelevant to legal validity. Justice is not a popularity contest. You're right, Sarah agreed. Justice isn't about making people happy. It's about solving their problems fairly and effectively. And your traditional methods consistently fail to do that. She closed her notebook and looked directly at the assembled legal scholars. So I'll ask you the same question I've been asking since I arrived. What would your mother think if she knew you spent your career perfecting procedures that don't actually help people? The question rippled through the chamber like a revelation. For the first time in millennia, legal professionals found themselves confronting not the technical adequacy of their procedures, but the practical value of their work. The silence stretched until Junior Arbitrator Velthak stood from his position in the tribunal delegation. My mother, he said quietly, spent 17 years trying to resolve a property dispute through traditional legal channels. She died before the case was concluded. The legal precedent established by her case was cited in textbooks as an example of excellent jurisprudential analysis. But she never got her property back. His confession opened floodgates of similar acknowledgments. One by one, legal professionals began sharing stories of cases where procedural perfection had failed to deliver practical justice. The accumulated weight of institutional authority began to crumble, as the people who had built it recognized its fundamental inadequacy. Grand Jurist Morvak made one final attempt to restore traditional order. Individual anecdotes cannot override systematic legal principle. The rule of law requires consistent application regardless of particular circumstances or emotional appeals. The rule of law, replied Chief Arbitrator Velthak, exists to serve justice, not the other way around. If our laws consistently fail to deliver justice, then our laws are wrong. The formal review dissolved into something unprecedented in the history of galactic jurisprudence, an honest conversation about whether legal institutions were actually serving their intended purpose. The conversation continued for hours, with legal professionals from across the galaxy grappling with the possibility that their life's work might need fundamental transformation. The resolution came not through formal vote or judicial decree, but through gradual recognition that the experimental methodology had demonstrated something undeniable. Justice was better served through practical problem-solving than through adherence to traditional procedure. 6 months later, the Galactic Tribunal had been transformed into the Galactic Resolution Center. The obsidian Tower of Justice still pierced the crimson sky of Nexus Prime, but its chambers now featured collaborative workspaces instead of formal courtrooms. Legal professionals worked alongside technical experts, community representatives, and anyone else whose knowledge might help resolve disputes effectively. The transformation spread throughout galactic civilization. Legal education programs began teaching problem-solving alongside precedent analysis. Government agencies measured their success by practical outcomes rather than procedural compliance. The phrase, "What would your mother think?" became a standard test for institutional policies across thousands of worlds. Sarah Martinez returned to Earth after her advisory period ended, but the changes she had catalyzed continued rippling through galactic society. The simple question that had started as curiosity about practical relevance had become a fundamental challenge to institutional authority that prioritized its own preservation over its stated purpose. Chief Arbitrator Velthak, now Director of Collaborative Resolution, kept Sarah's original notebook in his office as a reminder that the most profound changes often begin with the simplest questions. The galaxy had learned that justice was not about perfecting procedures, but about helping people solve their problems fairly and effectively. The revolution was complete, not because institutions had been destroyed, but because they had remembered their original purpose. And that purpose, it turned out, was best served not by asking what the law required, but by asking what justice demanded. Up next, you've got two more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out.